Hello, welcome to our classes. I am Dr. K. Misra. This video tutorial I am going to discuss Companies Act 2013. This is in series of discussing companies key highlights of Companies Act 2013. This is part 5 of this series. Herein I would be discussing the share capital and debentures. Now, Companies Act 2013, share capital and debentures. Before I start, I must tell you that the complete detail is not discussed here, only the key highlights. Share capital and debentures. The chapter on share capital and debentures introduces some key changes in the 2013 Act. To illustrate, the 2013 Act does not give any cognizance to the existing requirement of Section 90 of Companies Act 1956 that provided some saving grace to private companies. Therefore, the applicability of following sections of the 2013 Act is no longer restricted to public companies and private companies which are subsidiaries of a public company and are now applicable to private companies also. Two kinds of shares capital, new issue of shares capital to be only of two kinds, and voting rights. These points will be covered. First, voting rights. The provisions of 2013 Act regarding voting rights are similar to the existing section 87 of the Companies Act 1956. The only change noted in the 2013 Act is the removal of distinction provided by the Companies Act 1956 with respect to the entitlement to vote in case of the company fails to pay dividend to its cumulative and non-cumulative preference shareholders. This is highlighted in section 47 of Companies Act 2013. The provisions regarding private placement and additional disclosures in prospectus will also help to strengthen the capital markets. The Companies Act 2013 proposes to reinstate the existing concept of the shares with differential voting rights. Pursuant to this section, the company may face hardship with regards to computation of proportionate voting rights. Variation of shareholders' right, excuse me, similar to the other provisions of the 1956 Act. The 2013 Act acknowledges the requirements of Section 106 of the Companies Act 1956 with an additional requirement in respect of those classes of shareholders whose rights are affected pursuant to any variation. The proviso to Section 48 Class 1st of 2013 Act states that if the variation by one class of shareholders affects the rights of any other class of shareholders, the consent of 3/4 of such other class of shareholders shall also be obtained, and the provisions of this section shall apply to such variation. Application of premiums received on issue of shares. The 2013 Act lays down a similar requirement in section 52 as that of the section 78 of the Companies Act 1956 in respect of application of premiums received on issue of shares. However, the section of 2013 Act has a non-obstante provision in respect of certain class of companies which would be prescribed at a later date. The 2013 Act states that these classes of companies would not be able to apply the securities premium towards the below specified purposes unless the financial statements are in compliance with the accounting standards issued under Section 133 of Companies Act 2013. Paying up unissued equity shares of the company as fully paid bonus shares, writing off the expenses of or the commission paid or discount allowed on any issue of equity shares of the company, purchase of its own shares or other securities. The 2013 Act restricts the application of securities premium for a certain class of companies if they fail to comply with the accounting standards. The Act continues to state that securities premium amount can be utilized for purpose of writing of preliminary expenses. However, in view of the requirements of accounting standard 26 intangible asset, the requirement of this subsection appears to be superfluous. Issue and redemption of preference shares. The existing requirement of sections 80 and 80A of the Companies Act 1956 with respect to the issue and redemption of preference shares continues to be acknowledged by the Companies Act 2013. The Companies Act 2013 reiterates the existing requirement that a company cannot issue preference shares with a redemption date of beyond 20 years. However, it gives an exemption for cases where preference shares have been issued in respect of infrastructure projects. Infrastructure projects have been defined in Schedule 6 of the 2013 Act, and these shares would be subject to redemption at such percentage as prescribed on an annual basis at the option of such preference shareholders. Further, the 2013 Act adds another administrative requirement of obtaining special resolution with respect to the preference shares which could not be redeemed by a company. The Act states that where a company is not in position to redeem any preference shares or to pay a dividend, if any, on such shares in accordance with the terms of issue, it may, with the consent of the holders of 3/4 in value of such preference shares and with the approval of the tribunal, issue further redeemable preference shares equal to the amount due, including the dividend thereon, with respect to the unredeemed preference shares. On the issue of such further redeemable preference shares, the unredeemed preference shares shall be deemed to have been redeemed. The Act does not envisage any penalty in respect of non-compliance with the provision of this section, as was prescribed in subsection 6 and 3 of section 80 and 80A of the Companies Act 1956 respectively. Section 55 of Companies Act 2013 states this, in fact, change in detail. The Act does not envisage, in fact, this has been covered there. Now, fifth, prohibition on issue of shares at a discount. Companies would no longer be permitted to issue shares at a discount. The only shares that could be issued at a discount are sweet equity, wherein shares are issued to employees in lieu of their services. This is given in section 53 and section 54 of Companies Act 2013. Further, explanations first and second to the existing section 79A of Companies Act 1956 that prescribe the provisions in respect of sweet equity have not been included in the 2013 Act. Explanation first defined company for the purpose of this section, and explanation second defined sweet equity. Now, refusal of registration and appeal against registration. The provision relating to refusal of registration, of transfer or transmission of securities by private and public companies has been separately clarified in the Companies Act 2013. The private and public companies are required to send notice of refusal within 30 days of the receipt of instrument of transfer, and aggrieved party may appeal to the tribunal against the refusal within the specified number of days. The detail of it is given in section 58 clause 2nd of Companies Act 2013. Further issue of share capital. The existing requirement of section 81 of the Companies Act 1956 in regard to further issue of capital would no longer be restricted to public companies and would be applicable to private companies also, since subsection 3 of section 81 of the Companies Act 1956 has not been acknowledged in the 2013 Act. Further, the 2013 Act provides that a rights issue can also be made to the employees of company who are under a scheme of company's stock option, subject to a special resolution and subject to conditions as prescribed. Further, the price of such shares should be determined using the valuation report of a registered valuer, which would be subject to conditions as prescribed. This is given in section 62 of Company Act 2013. Issue of bonus shares. The existing 1956 Act does not have any specific provision dealing with issue of bonus shares, although it has referred to the concept of bonus shares at many places. The 2013 Act includes a new section that provides for issue of fully paid up bonus shares out of its free reserves for or the securities premium account or the capital redemption reserve account, subject to the compliance with certain conditions such as authorization by the articles, approval in the general meeting, and so on. This is highlighted in section 63 of Companies Act 2013. Unlimited company to provide for reserve share capital on conversion into limited company. This section corresponds to section 32 of the Companies Act 1956 and seeks to provide that an unlimited company having a share capital may be re-registered as a limited company by increasing the nominal amount of each share, subject to the condition that no part of the increased capital shall be capable of being called up except in the event and for the purpose of the company being wound up. The 2013 Act further provides that a specified portion of its uncalled share capital shall not be capable of being called and except in the event and for the purposes of the company being wound up. Section 65 of Companies Act 2013 highlights this change. Reduction of share capital. The 2013 Act gives cognizance to one of the amendments made in the listing agreement by SEBI. A new clause 24 subsection first was inserted to the listing agreement, which provided that a scheme of amalgamation or merger or reconstruction should comply with the requirements of section 211 3C of the Companies Act 1956. A similar requirement has been introduced in section 66 of Companies Act 2013, which states that no an application for reduction of share capital shall be sanctioned by the tribunal unless the accounting treatment proposed by the company for such a reduction is in conformity with the accounting standards specified in section 133 or any other provision of the Companies Act 2013, and a certificate to that effect by the company's auditor has been filed with the tribunal. Further, the 2013 Act clarifies that no such reduction shall be made if the company is in arrears in repayment of any deposits accepted by it, either before or after the announced commencement of the 2013 Act or the interest payable thereon. Power of the company to purchase its securities. The existing provision of section 77A of the Companies Act 1956 has been acknowledged by the Companies Act 2013 also. The only difference is that the option available to company for a buyback from odd lots is no longer available. Section 68 highlights this fact of Company 2013. The Act provides flexibility in management and administration by recognizing the electronic mode for notices and voting, which is in line with the MCA's efforts to give cognizance to use of electronic media, as evident from a number of green initiatives introduced recently. Maintenance of registers and returns at a place other than the registered office. So this was all about this video tutorial. I hope that you have liked it, and if you have liked it, please do not forget to subscribe my YouTube channel or classes and press the bell button and pass it on to others, those who are needy now and in the future. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.